There is a number where your California asset protection plan stops being a wall and it starts being a negotiation. Below that number, opposing counsel takes a smaller settlement or walks away. Above it, your domestic plan becomes the place the fight begins, and the question is whether it can actually survive that fight. The number is not theoretical. Experienced credit attorneys actually calculate it the same way every time. They look at how much equity you have, what entities you use, what jurisdiction you sit in, and at what point pursuing your assets stop being worth the cost. By the end of this video, you are going to know where that line is, what happens on both sides of it, and how to build a structure that makes the math come out the wrong way for the opposing counsel, no matter how large your net worth becomes. This is the video where domestic planning ends and the next level begins. Let's start with what a creditor attorney actually sees when they look at a well-built California plan. They're going to see the land trust, no equity showing in your personal name on the public record. They are going to see the operating LLC with charging order protections and restricted transferability that makes a forced sale complicated. They see the Wyoming holding company above it with a stronger charging order statute and another layer between any judgment and your assets. And they're going to see the California third-party irrevocable trust holding assets for the benefit of your family outside of your personal estate with spendthrift provision limiting their options. That picture creates real friction, and for most California investors, that is where the math goes against the attorney and they move on. But let me tell you what that picture does not actually show you, and what your own attorney may have not told you. Every entity, every trust, every LLC, every agreement operates within the same court system that just issued its judgment. A California judge can interpret your trust provisions, can order full financial discovery in your structure, can look at the documents and ask whether they actually do what they claim to do. There is no jurisdictional wall. The creditor is still operating entirely within the same system they already won in. Okay, so now you're thinking, what about a Nevada domestic asset protection trust? What about a South Dakota trust? Other attorneys bring these up, and there is a version of reality where they work. Nevada and South Dakota and 19 other states, I believe, have domestic asset protection trust laws that allow you to create an irrevocable trust where you are a beneficiary and still will get creditor protection after a waiting period. Those statutes are real for residents of Nevada and South Dakota and the other states that have those statutes. I'm assuming you're in California and that probably won't work for you. For a California residents, the enforceability question is material. A California court applying the probate code section 15304 may decide that your Nevada domestic asset protection trust created by a California resident to protect California assets is subject to California law, which means the self-settled trust is reachable. You can layer a domestic asset protection trust into a broader structure and it adds something, but if the creditor's attorney knows what he or she is doing, he or she will make the argument. So your domestic plan, your domestic asset protection plan doesn't have a jurisdictional barrier. A domestic asset protection trust doesn't reliably solve it, and you cannot create an irrevocable trust in California where you are both a beneficiary and protected because of Probate Code Section 15304. So the domestic ceiling is real, and it sits exactly where your collection-savvy adversary knows it is. Offshore jurisdictions exist entirely outside of that ceiling. In the Cook Islands, Belize, Nevis, and a few other jurisdictions, you can create an irrevocable trust where you are a beneficiary and creditors cannot reach it. That is not a workaround. That is what the law in those jurisdictions provides. Because the trust is governed by foreign laws, a California court's opinion on your trust structure carries exactly zero legal weight in the Cook Islands. Their law governs their court. Your California creditor does not operate there. More specifically, a California judgment cannot be domesticated in Cook Islands at all. A creditor who wins in California and wants to pursue trust assets held offshore has to start a brand new proceeding under the Cook Islands law. The burden of proof is beyond reasonable doubt. Creditors must file in Cook Islands court within 1 year of the assets transfer, and transfers made more than 2 years before the creditor's claim arose cannot be challenged as fraudulent at all. The U.S. judgment is not recognized. In Nevis, the bar to entry is even more direct. Before a creditor can file a claim against a trust, they're required to post a $100,000 bond with the local court. That single requirement eliminates most speculative claims before any legal work even begins. Here is how to know whether you're above the domestic asset protection ceiling. 5 questions. If you answer yes to 2 or more, you need to keep watching. First question, is your total combined exposure, real estate equity, liquid asset, business interest, more than $2 to $3 million? Second question, are you in a profession or an industry where large, unpredictable claims are realistic? Physicians, surgeons, developers, contractors, business owners with significant employee exposure. Third question, do you hold significant liquid assets, cash, brokerage accounts, securities outside of real estate equities? Fourth question, do you need or want direct access to the income from an irrevocable protective trust? All right, and the fifth and the last question is that do you want your assets to sit under more than one legal jurisdiction? Not because you distrust U.S. courts, because strategic redundancy is the same principle as portfolio diversification. If you answered yes to 2 or more of these questions, the domestic plan is your foundation, but it isn't your ceiling. However, for most California investors at this stage, the practical entry point is not a full offshore trust from day one. It is what I call an adaptive trust. The trust is irrevocable the moment it is signed, but it starts fully domestic right here in the U.S. The grantor serves as the initial trustee, and because the grantor retains trustee powers, the trust qualifies as a domestic grantor trust under Internal Revenue Code Section 677. There would be no foreign reporting, no Form 3520A, minimal offshore trustee fees. It files and operates as a standard domestic structure. What makes it different, it's what's built inside of the trust document. And I'm referring to the triggering provisions. When a genuine threat materializes, an offshore successor trustee steps in, administration moves from domestic trustee to the offshore jurisdiction. The assets were already inside of the irrevocable trust structures before the threat arrived. So the fraudulent transfer argument, the claim that you moved assets to avoid a specific creditor, is dramatically weaker. The structure was in place. The trigger activated something that was always part of the plan. The offshore component costs you very little until you need it, and when you do need it, it's already built. Okay, so maybe you've decided you might need an offshore asset protection trust. Now the question is how it actually works. Most people picture hidden accounts and tax evasion. The reality is completely different. The structure is legal, fully reported to the IRS, and a lot more interesting than the media version. And that is next. If you found this video first and you're trying to figure out where the foundation is, you have to go back and watch my video called What is Asset Protection and Why You Should Care. That video is where this series starts. Start there, and I look forward to seeing you over there.